Hello guys, welcome to my channel. This is Attorney Pagdanganan, and for today we will be discussing Labor Law 101. Okay, it's basically common HR or management issue. So let's start. Okay. So we have here frequently asked questions from supervisors or managers. So first scenario here is my staff always do things or does things on her own despite telling her how things should be done. So she has her own way of doing things, which sometimes results to project delays or miscommunication with other departments because she does not follow instructions. So how do I deal with her? This is coming, I suppose, from a supervisor or a manager. Can I file for insubordination? So to address this question, we go to first, follow the handbook or policy on disciplinary measures for erring employees. So how do you actually handle erring employees? Definitely your handbook or personnel handbook or policy guidelines for disciplinary measures should contain the procedures for this. Okay? And next, we should define what insubordination is. Okay? Insubordination is defined as a refusal to obey some order which a superior officer is entitled to give and have obeyed. The term imports a willful or intentional disregard for a lawful and reasonable instruction of the employer. So here, the supervisor or the manager acts as an agent of the employer. So when the employer, through the manager or supervisor, gives out an order, so there should be an order. It should either be written or it should be verbal. It can be verbal or written. There you have an order which should be obeyed, and yet the employee refuses willfully to obey this particular order. And it can come in the form of policy. Okay, so you're supposed to follow policy with regard to, let's say, answering calls or how you dress up in the office. So it can fall under insubordination, but take note, the elements should all be there. There should be an order. There is willful or intentional disregard of that order. And for purposes of termination, you cannot just invoke insubordination. Okay? So there, we will go to that later, actually, in some other questions. That would be willful disobedience. So insubordination is not necessarily or will not necessarily fall under willful disobedience, which is a terminable offense. Okay, moving on, we have the second scenario. So it's the manager says, I have a tenured staff whose performance is above average in the past years. He has been with us for 4 years already, and this year his performance seems to be lagging. So meaning it has deteriorated over the past period. So can I terminate him for this year's specific performance without giving consideration of his performance in the past years? So meaning you disregard the previous year's performance and then you only consider what he has, how he has performed for this recent periods or recent year, let's say January to June or July to December of the previous months. So in order to answer that question, first we should consider our handbook or policy on performance of employees. How do we actually rate these employees? So uh, are there evaluations cumulative, meaning if they perform, let's say, poorly for January to June, can they have a good performance for July to December or so? So based on policy, should it be cumulative, or does it matter whether the employee actually performed well in the first half or the first quarter, and will it affect his or her performance in the second and third quarter or the second half of the year? Okay. Next, we should define poor performance in relation to gross neglect of duty. So when is the employee actually poorly performing? Okay. So showing that a worker was inefficient in his or her work and negligent in his and her duties may constitute a just cause for termination under Article 282B of the Labor Code. And that would be gross and habitual neglect by the employee of his duties. Okay, so moving on. So if an employee is inefficient in his or her work, it may be a ground for termination. So it would actually first depend on the policy, of course, as I mentioned earlier. So, but other than that, so to show that dismissal resulting from inefficiency in work is valid, it must be shown. So these are the requisites. The employee has already set the standards of conduct and workmanship against which the employee will be judged. So meaning there are standards that are given. So how many calls can you or are you supposed to make, etc. So how many clients are you supposed to service for a particular period. Second, the standards of conduct and workmanship must have been communicated to the employee. Even if there is already a standard, if these standards were not communicated to the employee, it doesn't really count as inefficiency with regard to that particular employee. He doesn't know about it. All right. So if he's the only one who doesn't know about it, there has to be something wrong. Third, the communication was made at a reasonable time prior to the employee's performance assessment. So you cannot be informed with as regards to the standards after you've already performed. So these standards should be communicated within a reasonable time before the employee performs the job or the employee gets assessed or evaluated. So he should know beforehand how he will be evaluated. Okay. So this is similar to the law and jurisprudence on probationary employees, which allows termination of the employee only when there is just cause when the probationary employee fails to qualify as a regular employee, meaning we apply the rule with regard to probationary employees. And what is that rule? So you cannot just dismiss or terminate an employee because he is poorly performing. He should be informed of the reasonable standards that is required of him, and these standards should be given to him before he starts. And he should be informed also as to the criteria upon which he will be evaluated. So there. So the reasonable standards made known to the employer, made known by the employer to the employee at the time of his or her engagement. So the employer on a regular basis determines if an employee is still qualified and efficient based on work standards. So we apply the rule on probationary employees, meaning even if he's already a regular employee, if he becomes inefficient at any time, even after his regularization or during the period where he is already a regular employee, okay, so he should be informed of this. He should also be given the chance to improve, okay? So based on that determination and after complying with the due process requirements of notice and hearing, the employee may exercise its management prerogative of terminating the employee found unqualified. Okay, the regular employee must constantly attempt to prove to his or her employer that he or she meets the standards for employment. So you cannot just uh, perform poorly after you become regularized or after your probationary employment, then you become a regular employee. You're not supposed to dwindle in your performance. Okay, that's the case of Samir Overseas Placement Agency Incorporated versus Cabiles. So now we have, or we go to the third scenario. I have a staff who is under probationary employment or period. His performance is not meeting expectations. When I met with him during the probationary performance evaluation, he explained he did not know the specific expectations of the manager and he did not receive feedback about his performance only until the probationary performance evaluation came. So can I still end his probation period? Take note, the probation period is set already by law, which should not exceed 6 months. So again, my answer to this scenario would be first, follow the policy or handbook with regards to performance evaluation of employees. Next, we should define the probationary period and probationary employee, and we should know when the evaluation should be made. On that note, we have here Article 295 of the Labor Code, which says that probationary employment shall not exceed 6 months from the date the employee started working unless it is covered by an apprenticeship agreement stipulating a longer period. So we see here that a probationary employee is one who is on trial by an employer during which the employer determines whether or not he is qualified for permanent employment. So you are being gauged whether you are qualified or not for purposes of regular employment. So the employer observes the fitness, propriety, and efficiency of a probationer to ascertain his qualification for permanent employment, and the probationer seeks to prove to the employer that he has the qualifications to meet the reasonable standards for permanent employment. And that's from the case of International Catholic Migration Commission versus NLRC. Now we go to the general rule. So probationary period should not exceed 6 months from the date the employee started working. That's under Article 295. But we have exceptions to that. So general rule, there should be, before the employee becomes regular, he should undergo 6 months probationary employment. The exceptions are the following: when the parties actually agreed to a shorter period, let's say 3 months, or a longer period, let's say 9 months. When the same is established by company policy, of course, when the policy of the company is to have a probationary period of only 4 months or 5 months, so, and that is also favorable to the employee, then you apply that policy. Third exception is when the same is required by the nature of the work performed by the employee. Let's say his particular work requires training of at least 9 months because of the level of difficulty in performing a particular job. Fourth, we have the exception that if the employment is covered by an apprenticeship agreement which requires a longer period of probation. Okay. So what are the grounds? Okay, so general rule is that even if the employee is on probation or a probationary employee, he is still entitled to security of tenure. That means he cannot be removed at the whim of the employer. You cannot just ask for the employee to be removed from his or her position. Okay, the probationary cannot be dismissed except for the following grounds. One is for just causes, which we will also discuss a bit later. Or second, when he fails to qualify as a regular employee. So that only happens after evaluation of the performance of the employee and within a certain period within which his performance should be evaluated. Of course, you will use as basis the either the employment contract or the handbook of the company. So we have these limitations on termination of probationary employees. First, it must be exercised in accordance with specific requirements of the contract. Of course, what does this mean? So the contract should state what are these qualifications, what are the metrics that will be used in order to measure the performance of the employee. If a particular time is prescribed, the termination must be within such time, and if formal notice is required, then that form must be used, or that period should be observed. So it should be, let's say the contract says it should be written, it should be, the employee should be notified within a period of 30 days prior to the termination of his employment, then that should be followed. Third, the employer's dissatisfaction must be real and in good faith. It should not be simulated, invented, or it should not be feigned so as to circumvent the contract or the law. So it should be exercised in good faith. This right of the employer to terminate the probationary employment of the employee. So fourth limitation is that there should be no unlawful discrimination. So meaning, oh, just because this person, let's say I don't like, I'm the supervisor and I don't like the person's face, so I am not authorized by law to just recommend his dismissal or to ask management to proceed with terminating his employment. So those are the limitations with regard to termination of probationary employee. So this cannot be done dilly-dally or without considering these factors of due process and the formal requirements. So we have now the fourth scenario. I have a staff who have just just passed probation. He was regularized on his 5th month in the company. On his 6th month, he started to show misbehavior. So meaning he misbehaved or he did something wrong after he got his employment was converted from probationary to regular. So now he shows tardiness and absences and so many errors in his job. So can I still terminate him even if he has just passed the probation period? So meaning from probationary, the employee has just become regular. So what's my answer? My answer would be first to follow. Again, I cannot overemphasize that we should always follow the policy or the handbook with regard to performance evaluation of employees. And take note, you should always document whatever happens in the office. Let's say there's an incident where the employee was tardy or the employee was absent several times, and this should be in the form of a memorandum. Okay. So next, we should define what a regular employee is and what are the rights, obligations of a regular employee. So a regular employee is one who is engaged to perform activities that are necessary or desirable in the usual trade or business of the employer. So based on this definition, so the regular employment of a person is dependent on the nature of the work or the activities that he or she performs, which are supposed to be necessary and desirable in the usual trade or business of the employer. So regular employment is based here from the first definition based on the necessity and desirability of the activities that the employee actually performs. Second, a casual employee who has rendered at least 1 year of service, whether continuous or broken, with respect to the activity in which he is employed. So now we are talking about a casual employee who has rendered at least 1 year of service. So that makes him a regular employee. So whether continuous or broken with respect to the activity in which he is employed. So however, even if an employee is engaged to perform activities that are necessary or desirable in the usual trade or business of the employer, it does not preclude the fixing of employment for a definite period. So meaning, even if the activity is usually necessary and desirable in the trade or business of the employer, meaning the company, it does not preclude or it will not compel the company to make him a regular employee. So, or there, the company or the corporation or the employer may always fix the employment period of the employee. So even if let's say I hired let's say a an employee who performs activities that are usually necessary and desirable in my business, it doesn't mean that he is already regular because I can always make him a fixed term employee or fixed period employee. So meaning I can only hire him for a specific period, let's say 1 year, okay? And after that, I can terminate his services. Okay. So we have now the fifth scenario. I have a staff who does not get along with me or our relationship is not mendable or repairable. Despite many one-on-one sessions, I just want him out of my team and no other department is willing to absorb him. How can I terminate him with legal basis? So can you actually terminate that person or that employee with legal basis? Answer is I will give you the definition of security of tenure and we will go or we will discuss the just authorized causes for termination. So security of tenure says under Article 279 of the Labor Code that in cases of regular employment, the employer shall not terminate the services of an employee except for a just cause or when authorized by this title. So we're talking about two causes for terminating the employment of an employee. So we're talking now of a regular employee. So meaning, so to put the article in simple terms, so if an employee is a regular employee, he can only be terminated or dismissed from his employment based on two causes, just and authorized causes. Okay, so what happens now if the employer dismisses the employee from his work without complying with these just or authorized causes? So that person or that employee will be entitled to reinstatement without loss of seniority rights and other privileges and full back wages inclusive of allowances and other benefits or their monetary equivalent computed from the time his compensation was withheld from him up to the time of his actual reinstatement. So these are the consequences of not following the law with regard to the grounds for terminations. First is that there should be reinstatement. There's no loss of seniority rights. He should be given full back wages. Okay. He should be given always allowances and benefits and the monetary equivalent of the same computed from the time his compensation was withheld. Okay. So in the case of Bascon versus Court of Appeals, the law says or the Supreme Court said the doctrine of strained relations. So even if the law says there should be reinstatement if there are already strained relations between the employer and the employee, then the employee is only entitled to, instead of reinstatement, he will be entitled to separation. Okay. Okay. So employer's power to dismiss must be tempered with the employee's right to security of tenure. Okay, the Supreme Court said time and again, we have said that the preservation of the lifeblood of the toiling laborers comes before the concern for business profits. Employers must be reminded to exercise the power to dismiss with great caution, for the state will not hesitate to come to succor of workers wrongly dismissed by capricious employers. Okay, so we have here the doctrine of strained relations. Under Article 297, we have here the just causes for termination of employment by the employer. So here, the employer dismisses or terminates the employment of the employee based on the behavior of the employee. First ground is serious misconduct. Okay. So second is willful disobedience by the employee of the lawful orders of his employee or representative in connection with his work. So we have two grounds on the first paragraph. Second, we have gross and habitual neglect by the employee of his duties. Next, we have fraud. So we have two grounds again, fraud and willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. We have another ground, which is commission of a crime or offense by the employee against the person of his employer or any immediate member of his or his family, or his duly authorized representatives. And of course, we have other analogous causes. So the law did not specify everything. So the law includes other analogous causes. Okay, so that's your just causes for termination. Now we go to number 6 scenario. I have a staff who did not allow our team's major SOP and he concealed it to me and to the other teams. According to our code of conduct, not following SOP falls under minor offense. But since he has done this for a few times already, I do not want to consider it still as a minor offense. I would like to terminate him. Can this be considered a breach of trust since he always tries to hide important incidents to me? So here the manager or supervisor is already asking with regard to breach of trust. Is that the proper ground with regard to concealment of, let's say, an error or failure to comply with the standard operating procedure? My answer is that what are, first, we have to define what a minor and a major offense is. So if it's a minor offense, we're talking about an offense which is non-terminable. So these are petty offenses or violations that do not merit termination or dismissal of employment. So as distinguished from a major offense, which is a terminable offense or an offense that merits termination or dismissal regardless of the number of times committed. So even if it's only committed once, it may be a ground for terminating the employment of the employee. So we have here also under scenario 6, the totality rule. So in Merin versus MRC, the Supreme Court ruled that in determining the sanction imposable to an employee, the employer may consider and weigh his other past infractions. Thus, the totality of infractions or the number of violations committed during the period of employment shall be considered in determining the penalty to be imposed upon an erring employee. So the offenses committed by the petitioner should not be taken singly and separately. Fitness for continued employment cannot be compartmentalized into tight little cubicles of aspects of character, conduct, and ability separate and independent of each other. While it may be true the petitioner was penalized already for his previous infractions and does not and should not mean that his employment record would be wiped clean of his infractions. After all, the record of an employee is a relevant consideration in determining the penalty that should be meted out, since an employee's past misconduct and present behavior must be taken together in determining the proper imposable penalty. So that's your totality of the offense rule. So just because the employee has already been penalized for his previous misbehavior doesn't mean that his previous misbehavior will not be considered in imposing the penalty for his current or latest misbehavior. Okay. With regard to breach of trust or loss of confidence, here are the requisites. So loss of confidence must not be simulated, meaning it should not be invented or just a simulation on the part of the supervisor or manager. Should not be used as a subterfuge for causes which are improper, illegal, or unjustified, meaning they cannot feign loss of confidence for purposes of removing an employee. Okay? It may not be arbitrarily asserted in the face of overwhelming evidence to the contrary. So you cannot just raise or invoke the ground of loss of confidence when you terminate an employee. It should be proven with evidence. So it must be genuine and not a mere afterthought to justify earlier action taken in bad faith. Okay. And lastly, based on the 2010 case of Coca-Cola Export Corporation versus Gakayan, the employee should hold a position of trust and confidence. So if you're saying that you lost your trust and confidence in that employee, it presupposes that the employee should be involved or holds a position of trust and confidence. Okay? So on that ground alone, the termination of the employee may be invalidated. So even if you have all the four requisites, but if you do not have the fifth requisite, which is the requirement that the employee should hold the position of trust and confidence, then your termination of an employee on the ground of loss of trust and confidence will be considered invalid by the labor or the NLRC. Okay, so what are these positions of trust and confidence? A position where one is entrusted with confidence on or with the custody or care protection of the employer's property is a position of trust and confidence. We have two classes of positions of trust and confidence. We have managerial positions and non-managerial positions, or those positions uh, whose holders regularly handle significant amounts of money or property in the normal and routine exercise of their function. So with regard to managerial positions, the mere existence of a basis for believing that the employee has breached the trust would suffice for his dismissal. So with regard to managers, as long as there's a basis to believe that the employer should lose the trust and confidence given to that manager or that employee, then this ground may be invoked for terminating a manager. However, for non-managerial employees, it is not the same because it requires proof of involvement, and mere uncorroborated assertions or accusations are insufficient. So you cannot just suspect that an employee is doing something without proof and then terminate his services or his employment. Okay, an example here, let's say a human resource director's lack of working knowledge of labor law is a valid cause for dismissal based on loss of trust and confidence. So we're talking here about a human resource director. So next example is failure to reach sales or production quota is not a just cause for termination based on loss of trust and confidence because it's not a willful act. It will not comply with the requisites that we mentioned in the earlier slides. Now we go to the next scenario, scenario number 7. The staff works in the office and he did not follow the COVID-19 protocol. Can we link the government's violation of COVID-19 protocol to workplace violations, such as penalties or imprisonment for government and workplace? Can we go directly for termination in this case? So, in other words, can you terminate an employee on the basis of failure to comply with government workplace protocols? My answer would be violation of health protocols according to the handbook. So we will refer back to the handbook, whether it is a terminable offense or not. Second, we should consider criminal offenses under the labor code. And if you recall, the criminal offenses under the labor code, which is a ground or is a just cause for termination, is directed towards the employer himself, his relatives, or representatives. So, is an offense, let's say, failure to comply with government health protocols, a criminal offense which is terminable based on these grounds? To my mind, it is not a terminal of offense based on commission of a criminal offense. Okay? So, criminal offense is a just cause for termination. So, it should be committed against the immediate family members of the employer. So limited to spouse, ascendants, descendants, or legitimate natural or adopted brothers or sisters. So conviction or prosecution is not required. The fact that the criminal complaint was dropped by the city fiscal is not binding and conclusive upon the labor tribunal. So meaning the fact that there was a complaint filed against the employee is enough ground for the employer to terminate his services. Take note of the first requisite. It should be committed against immediate family members. Okay. All right. And of course the the company itself. So we go now to scenario number 8. I have a staff who always challenges my decisions for the team. He would always question me in terms of my why I come up with such decisions. As a manager, I am too stressed in dealing with staff and I want to terminate him because he is not respecting me as the manager. Is there a ground for me to do this? My answer would be to revisit the just causes for termination. So we should also consider the definition of disrespectful conduct under the handbook. What is serious misconduct as defined under our jurisprudence? It is a transgression of some established and definite rule of action, a forbidden act, a dereliction of duty, willful in character, which implies wrongful intent and not mere error in judgment. First requisite of serious misconduct is that it should be serious. The misconduct must relate to the employee's performance of his duty and it must show that the employee has become unfit to continue working for the employer. That's the case of Roquero versus PAL. So we have 3 requisites. Seriousness. It should be the misconduct must relate to the employee's performance of his duty and it must show that the employee is unfit to continue working for the employer. So 3 requisites. Examples of these: utterance of obscene or offensive or insulting words against a superior. That is considered as serious misconduct under Asian Design and Manufacturing versus Deputy Minister of Labor. Immorality does not justify discharge of an employee unless such conduct is prejudicial in some way or in some way detrimental to the employer's interest. So a teacher falling in love with her student is not immoral. In Chua Kua versus Clave, the Supreme Court said 2 teachers having extramarital relation is immoral, but not a teacher who falls in love with her student. Of course, sexual harassment in Villarama versus NLRC is serious misconduct. Theft of company property is a just cause for termination, but not theft of property not belonging or owned by the company. So we have the ninth scenario. I have a new joiner in my team who is barely a month in the company. However, his performance does not really seem to fit with what we need. Can I end his probation at this early stage and not wait for 6 months? Can you? So, of course, we already mentioned about probationary employee and security of tenure in the earlier slides. We have already mentioned due process requirements for probationary employees. Now we have here the limitations on termination of probationary employees. It must be exercised in accordance with specific requirements under the contract. This was mentioned earlier. If the contract says he should continue employment, then he should continue employment, even if he does not qualify. So if the contract says the employer may discontinue his employment after the third evaluation or evaluation of the third month and he is found unfit, then it will govern. So if a particular time is prescribed, the termination must be within such time. A formal notice is required, then that form must be used. So if it requires that there should be a written letter or notice to the employee, then that should also be followed before the employee is terminated. Okay. Third is that the employer's dissatisfaction must be real and in good faith, not feigned so as to circumvent the contract or the law. Okay. And lastly, there must be no unlawful discrimination in dismissing the employee. Termination must be done prior to the lapse of the probationary period. Of course, if you terminate the employment of the employee after the lapse of the probationary period, that means the employee is already regular. Okay, so you cannot do that. Second, peremptory and arbitrary termination is not allowed. So there's no obligation to pay the unexpired portion in case of valid termination prior to the lapse of probationary period. This is a common question. So if the employer wants to dismiss the employee on the third month, does he have to pay for the fourth, fifth, and sixth months? So the answer is no obligation to pay for the unexpired portion under the case of International Catholic Migration Commission versus NLRC. Okay. Fourth requirement, procedural due process is required only in case of termination due to just cause. Second ground of failure to qualify as a regular employee does not require notice and hearing. Of course, if your ground for terminating the probationary employee is his failure to comply with the standards, okay, then that does not require notice and hearing because that's already contained in your employment contract. And in fact, it's part of the law on probationary employment. Okay? So next is that due process is complied with by making known the reasonable standards expected of the employee during his probationary period at the time of the probationary employment. This was discussed earlier. Okay, and under Article 293, okay, on reinstatement of probationary employees. Hence, unjustly terminated probationary employees are entitled to reinstatement. However, when there is strained relation, separation pay in lieu of reinstatement is proper, which covers the period from the date of dismissal to the last day of the agreed probation period. Okay, so that ends our session for today. If you like this video, then please like this video and subscribe to our channel. Thank you. And this is Geoffrey Pagdanganan, your counsel, signing off. Thank you.